You filed for a trademark to protect your brand, but you're getting these notices in the mail. You're not quite sure what do they mean, and they're asking for money. Watch this video and find out if you're getting scammed. Okay, everybody, Stephen Key here, and I have a special guest, a trademark attorney. Tamara, thank you for joining inventRight TV.
My pleasure. Thanks for having me, Stephen. Excited to
Okay,
be here
last time.
again.
Well, thank you. I'm sorry I interrupted you. The last time we talked, we were discussing trademarks and why they were so important to protect your name. And we have a video that we've done. Find the video if you want to know more about trademarks, and we'll put a link down below so people can find that other video that we did. But today I want to talk about something a little bit different, a little bit differently. I filed for a trademark, and I get this notice in the mail, and it looks really official.
Hmm.
Or maybe I've have filed for a trademark, and somehow I'm having some difficulty getting it, and I get this email in the mail, or not in the mail, but this email, and or maybe I even have a trademark and I still get these notices about something about my trademark. Is that legit, or are those scams? Okay, you've got a great idea, but you're not quite sure exactly what to do. And you want the pros to do it, and you want the pros to do all of it. Please consider reaching out to us on Gateway, where we handle everything for you. We will find those right companies, we'll find those right people, and make sure your product is pitched correctly to get the licensing deal. It's called Gateway. Please check it out.
Those are scams, Stephen. What happens when you file a trademark application is that it takes a while. Right now, it's about 8.4 months, I believe, to get examined by the examining attorney at the Patent and Trademark Office. And then once they examine it, if you have filed as intent to use, and only if you have filed as intent to use, if you filed as use-based, you pay the fees up front, it'll get examined, maybe you get rejected. I mean, there's a lot of things that can happen along the way, honestly. But basically, you don't need to pay any more fees until between the fifth and sixth year, unless it's unusual circumstance. If you have filed as intent to use, you will get an email from the US Patent and Trademark Office. Either you will get it, or if you use an attorney, your attorney will get it because they're your correspondent of record, indicating that you've gotten a notice of allowance. If it's gone through the whole process, it's fine. You get what's called a notice of allowance. At that point, you have the option to either file a statement of use or file a request for extension of time for a statement of use. And there are fees associated with either the request for extension or the statement of use itself. Other than that, no more fees until between the fifth and sixth year once you're registered. There are can I share my screen for a second? I have a couple examples of these
Sure.
scammy letters that clients send me, and they're like, I thought you took care of my trademark. Why did I get this notice that there's more fees due? Well, because there's a lot of scams. So one option is it really looks like it's official on the left here from the Patent and Trademark Office. It's like, hey, we're offering to renew your trademark. For $1,090. These are the official fees for the trademark office. If you look, you see their mailing address is, it's not in Virginia, not in Arlington. No, it is in, that one is in Seattle, I think. Let me see if I can move this guy over.
Okay.
Yeah, Bothell, Washington. As far as I know, there's no patent and trademark office there. So that's a scam. You do need to file your renewal fees. Don't get me wrong. Between the fifth and sixth year, you do need to file the renewal fees. Right now, they're I believe $425 per class of goods or services. That fee is expected to increase. We don't know when, but sometime in the next few months. But anyway, it's not $1,000. That's just a scam, a solicitation. And then the other option is from this World Trademark publication, where again, it's $1,420. They're like, hey, you need to pay this extra fee in order for your trademark to get published. Well, that's also not true because there is no additional fee for publication other than, as I mentioned, just the normal fee for filing the statement of use or the request for extension of time to file the statement of use. So those are a couple of the physical mail pieces that have been going around. That's been for a while. Lately, the scammers have gotten more sophisticated. So yeah, not only are they sending mail in the US mail, they're also sending these really scary sounding emails that's like which are, again, they're like half true. There is some truthiness, or who's the president that had like truthiness and fuzzy math? So like they're like truthy, but they're not really true. So one variation is where they, if someone filed an application themselves, or if they are an owner of a business and their email is somehow public,
Okay.
then they'll get an email saying, from usually from a law firm, saying, or someone who claims to be an attorney, saying, hey, we are working with another client, and in our clearance search, we came across your business name and we noticed that you haven't registered for a trademark. If you do not register, you will lose all rights in your company name. So that's kind of scary, right? Like you've been doing for a business for a while. You obviously didn't watch our first video where we tell you you should file for a trademark. You've been doing business, you never really thought about trademarks, and then all of a sudden you think you're going to lose your rights in your company name. You're going to have to change your name. Well, that's really not true. Remember
So
how we talked about common law rights?
yeah.
So businesses always have common law rights beginning on the date of first use in the geographic region where they're using it. And usually these common law rights will predate this scammy thing that comes along where they're saying, we represent this other client. And also, by the way, like if you are representing another client, you would never contact the other party and offer to register their trademark, right? So that's one way it's a scam.
So
But
how
the
big
truth, the truthy part is that if you don't have your trademark registered, you are sort of at risk of not necessarily needing to immediately change your company name, but you may not be able to enforce your rights to the same degree that you would if you had a trademark registration.
how big a problem is this? Because it seems like I always get issues. To me, I just don't respond to them. I kind of know they're scams.
Yeah, that's good.
Is this a big business
Yeah,
for people or
yeah.
small business for people?
Sorry, what?
Is this big money or small money?
I
Scamming.
mean, they look pretty official, right? Those notices. So if they're getting 10 people a day to pay $1,400,
So how do
every
you
day.
so how do you really know? I mean, a lot of people are fairly new at this, and not that I'm new at this either, but I'm always kind of wondering too. What do I do if I get one of these and I'm not sure? What should I do?
Well, you can always check the status of your trademark online at uspto.gov and see if it really is. Like you'll see the details of the application and you will get renewal. Your renewal information will be sent to you or to whoever your correspondent is. You will get an official notification, but it'll come from, whatever renewals at uspto.gov, not some world trademark thing or something else. Or you can call, if you have an attorney, even a regular business attorney, you can call them and either they'll check or they'll call me and I'll check. But the easiest way really is just to check the USPTO website.
Okay, tell me this. Trademarks, I think, I wouldn't say they're easy to get, but most people think they can do it themselves. I've done it
Mhm.
myself.
Mhm.
But I've also run into problems doing it myself too. Does it just make sense to call you and just say, handle this for me?
I mean, I think so. It depends. If it's a really unusual word, that for sure is not anywhere being used, it's not in the USPTO database. You
But
probably could file it yourself. And as you know, I have that Learn Trademarks class where we do walk you step by step. But even then, I've had people tell me, I think the USPTO application is pretty straightforward. So as we discussed last time, you want to do a clearance search. before you file, right? You want to look through not only the USPTO database, but also Secretary of State records, preferably in all 50 states, internet, social media, Dun and Bradstreet records if you have access to that. And then you'll see if there is anyone out there or not. If it looks clear, then yeah, you can file. But
I
some
know,
people say that it's hard for them. I mean,
but
I
if
don't
I'm
know.
starting a business
Hmm.
and I'm going to be spending a lot of time and a lot of money,
Hmm.
it's very important for me to protect my brand.
Hmm.
Why would I cut a corner and not have a professional help me with that? Tell me where am
Yeah,
I really saving money there?
that's a good question. I mean, you probably are not going to be totally sure about the classification, how to identify your goods or services. Again, if it's something simple, like if you're selling cardboard boxes, I mean, and that's
Okay.
all you're doing, maybe you're okay. But usually people need an attorney to figure out what the description of goods and services. Well, first to do the clearance search, then to figure out the description of goods and services. They like to have an attorney of record so they don't get bombarded by these scammy emails, and be notified when the official dates are. And then to keep abreast of your trademark, monitoring and enforcing it.
Okay.
That's usually pretty valuable to a new business owner.
I
But yeah,
see.
some people cut corners. I mean, some people
Well,
also draft their own wills or, do their own real estate contracts. But
well,
personally, like I hired an estate planner and we use a realtor. So personal
well,
preference.
yeah, but I'm a big believer that if you're going to spend a lot of time and money, there's maybe some things to cut corners, but there's
Hmm.
certain things that you shouldn't cut corners,
Hmm.
right? And one of them is, I think, maybe the trademark kind of falls into that because at the end of the day, that is your brand, that is your intellectual property, that has value, especially if you want to sell it or even defend it, or let's
Hmm.
say, I'm on Amazon or someone's knocked me off on Amazon and I've got a
Hmm.
trademark and they're using my name.
Hmm.
Do I want to chase it down or do I want my, possible attorney, to chase it down a little bit? It has more weight than if I'm complaining or my attorney's complaining about it, correct?
Yeah. Yes. Generally, a letter from an attorney or an attorney contacting one of those platforms will have more weight than someone trying to do it themselves. Just last week, I was talking to a client whose trademark is being infringed, and he had spoken to the other party. At the time, neither of them were represented by an attorney. And the other guy's using like exactly the same mark for exactly the same services in the same geographic area. Okay, so there's definitely like no doubt trademark infringement here. Anyway, he told me he had like an informal conversation with him. And the other guy said, yeah, well, I guess I can change my brand, but it might take a year. And my guy was like, oh, a year? Yeah, okay. Meanwhile, every day people are calling, getting confused. They were at a trade show together, and people were like, wait, do you have another branch now? So since he hired me, now we're really narrowing that down into a time frame that's more reasonable.
Does
That's something that just, having an attorney to talk over these issues with, because I've been doing this for a long time, and a legitimate IP attorney can really be a good source of guidance, and prevent you from making a mistake where like it's just going to result in lost business for you.
Yeah, I think it's a little short-sighted. I want to talk about something a little bit different. Thank you for explaining the scams and some of the other things too, because they come at you all the time, and I'm like, what do I
Yeah.
do with these things? Explain to me, and we haven't, I don't know if we've talked about this or not, but I file for a trademark, right? And I'm not quite producing the product yet.
Hmm.
Okay. And they're asking me, am I selling it? And I'm not yet, but I plan to
Hmm.
sell it. Tell me about the differences when I file that application.
Yeah, so in that case, you would file as intent to use rather than use based. And you still, are going to follow the same process. You click through for the goods and services. The only difference is since you're not checking the box for use in commerce, you don't need to indicate a date of first use. You don't need to upload a specimen of use,
Okay.
showing the mark on the goods or services.
So let's,
And you will need to file, like we talked about a few minutes ago, you will need to file that statement of use when you eventually begin using it.
okay, great. So let's say I have let's say I have a couple of them. I'm not quite selling them yet, but I've got a prototype. It's got my name on the package. I'm ready to go.
Mhm.
And does that count for
No, you do need to have actual use in interstate commerce, which means
Okay.
that you're continuously selling the good or advertising the service. Services are a different story. We can talk about that. But for physical products, it does need to be continuous sales either across state lines or between the US and another country.
But
For services, like if you're starting a law firm or your marketing company, as soon as your website is up, you can claim use in interstate commerce because
oh,
the website's up and that's your advertisement for your services, right?
okay, so I've got to be in business, kind of basically.
Yeah, you do. And
Okay.
if you say that you are using it and you file that prototype or mock-up as the specimen of use and the examining attorney lets it go, you will get a registration, but now we're talking about fraud. And then if you ever have an issue down the road about trademark infringement, that's grounds to invalidate your registration. So that fifth and sixth year renewal, if you file both the Section 8 and the Section 15 affidavit, it becomes incontestable to challenges. So you got like a bulletproof registration, but fraud is always a way to pierce through that protection.
Okay. And did we talk last time about filing trademarks around the world? Did we talk about that last time?
I don't know if we did or not.
I'd like to
We
talk a little
can.
bit about that. Um,
Okay.
so let's say I've got this great trademark and I want protection not only here in the United States, but let's say I want it in Europe. Do I have to file? How do I do that? Does my
So it depends on the time frame. There is something called the Madrid Protocol, which allows you to file in a foreign country through the USPTO, through like an offshoot of the USPTO system, and you get the benefit of your US filing date. However, it needs to be done within the first 6 months after you file your US application.
oh,
After that, you certainly can file in another country, but you would need to obtain local counsel in order to do that.
okay. So I'm going to need help. I would need help with that. Correct. Pretty much.
Yeah.
But it's not like a translation, like if I'm going to file a PCT and I've got to take my patent and I need to translate it in some other language. It's not that difficult, is it?
No, you don't need to translate it. Nothing like that. You just have to go through the right protocol.
Okay. And what about the expense wise? How expensive is it different?
Depends how many countries you're filing in. Generally, it's around the same price per country as a US application. Some countries are more, some countries are less. And the expenses can really add up, honestly, if you're filing in multiple countries. So you better have your budget for that.
What about annuities? Is that what it's called, annuities or maintenance fees? What
Oh,
is
maintenance fees. Yeah.
because I know with
Yeah.
patents, it's so many years we have to pay these maintenance fees.
Mhm.
But in other countries, it's yearly. Is it yearly with trademarks? Do you know?
In other countries?
Yeah.
I don't think it's yearly. I believe the EU is every 10 years.
Oh,
And the other ones, I don't know, it depends on the country. I
oh,
don't do a ton. International filings are probably like 10%, 20% of my practice, maybe.
okay.
Um, so yeah.
Oh, very good. Well, thank you so much for helping explain to all of us trademarks. It sounds like such a simple thing. I don't think it is. You guys have,
It does seem simple. Well, the good news is, I think we might have touched on this last time, but as long as you are continuing to file your renewals, and again in the US, it's between your fifth and sixth year, between your ninth and 10th year, and then every 10 years after that, your trademark can last forever.
I love that. So, but let's say I miss one of those fees. Can I go back? Do I have to go back and refile it, or can someone sneak in there?
Uh, that gets a little complicated. You do have a 6 month grace period. Where you pay an additional fee and you can still file in the 6 month grace period. If you still miss the grace period, then your registration will become canceled, but you can file a new application with all the, if it's this, exactly the same information. If it's all the same information, you can file the new application. You can file what's called a petition to make special and ask for expedited examination of your application based on your inadvertent mistake failing to file the renewal fees. So it's not quite the same as having a continuous registration, but it gets you to the same place. And it needs to be done like basically immediately after you find out, and you need to check and make sure that no one else filed between your renewal date and when you file the petition to make special,
So
because
if I
that is the time period when you'd be vulnerable.
so if I hire you to handle all of this,
Mhm.
you notify me later if that comes up so I don't miss that date.
Yeah, of course. Yeah, we docket all of our deadlines. Yeah, we handle like over 600 applications and registrations. So if I was personally like putting them on a little notepad somewhere, that would be really hard to keep track of. We have an automated docketing system that we use. And yeah, every day actually my assistant is sending out
Okay.
um, reminders about deadlines. We start reminding people when the renewal window opens, and then it's like every month. And then after 6 months, it's like every 2 weeks. And the last month, we start to get really nervous. And then it's basically like every day. And then if they miss it, it's like, well, you're still in the grace period, but we need to get this done.
Okay. Well, thank you
Yeah.
very much, everyone. If you're thinking about protecting your brand and you need a trademark, check out her information down below where you might need some help. You might need a trademark attorney to protect yourself. Check it out. Thank you so much for coming on.
Yeah,
And
sure. Thanks for having me. I'm always happy to talk about trademarks, and you're such a great host, Stephen. We
well,
keep the conversation flowing freely.
you're so kind. Okay, everybody, thank you for watching InventRight TV. Until next time, we'll see you.